We are recording.
Good morning, everyone. My name's Jose Cisneros. Welcome to the Committee on Special Discipline Case Audit Committee meeting, part of the State Bar of California. It is September 9th, 2021 at 11:04 a.m. We'll begin this meeting with a roll call. Louisa, please take the roll.
Broughton.
Here.
Chen.
Here.
Cisneros.
Here.
Duran.
Here.
Stalag.
Here.
Shelby.
Present.
You have a quorum.
Thank you very much. A reminder to everybody that this meeting is being recorded. At this time, we'd like to open the meeting for public comment. Louisa will attempt to call members of the public in the order that they appear. Public commenters will be limited to 3 minutes of public comment. To facilitate hearing as many members as possible, we encourage you to not repeat points that were made by previous speakers. You will be notified when you have 30 seconds left to conclude your comments, and at 3 minutes, we will end your time. For those who are participating by Zoom video, you should have a function for virtually raising your hand. It's a little hand icon that should appear in the bottom center of your screen. If you wish to make a public comment, please click on the hand icon now, and the State Bar staff will call on you in the order that you raised your hand. For those of you participating by phone, you may do the same, virtually raise your hand by pressing *9. Press the star key and then the number 9 key. And again, we'll do the best to take you in the order you raised your hands, and then the staff will open your microphone so you can address the committee, again, restricted to 3 minutes per speaker. Louisa, do you see anybody requesting to make public comment?
I do not.
Again, would anybody like to make public comment at this time? Please raise your hand or press *9 if you're on the telephone. Okay, if nobody's asking to make public comment, we will close public comment. The first item on our agenda is to move into closed session. I will ask the committee members to check their email. They should now be receiving an email with a closed session link. We will move into closed session. And for members of the public, we'll be coming back after we finish closed session to this public session link, making any report if there is one, and moving on to our open session items. So with that, we'll see folks in our closed session. Thanks, everyone.
We are now recording.
Thank you. Hello, members of the public. The Committee on Special Discipline Case Audit has completed its closed session item. There is nothing to report out from our conversation in closed session. With that, we will now move on to the remainder of our agenda in open session. And our next item is a discussion regarding the study and development of recommendations to regulate attorney-client trust accounts.
Right. So Richard will kick us off.
Thank you.
All right. I'm awaiting Luisa's queuing of the PowerPoint. Okay. Well, good morning, everyone. Today's topic, as indicated by the chair, is client trust accounts. Along with Stephen Moad, the two of us will be going over the basics of client trust accounts, how they are regulated currently. We'll also look at how other states' bars regulate their client trust accounts. And we'll look at examples from Australia and Canada as well, along with examples of other forms of state and local audit. At the end of which, I'll enumerate a list of issues that the committee may wish to consider as it moves forward with its charge. But before we get into the client trust accounts, it seemed it would be helpful to situate this in the context of the committee's overall charge. So we can look at the first slide of that. So this is the charge as enumerated in the board resolution, which can be found on the State Bar's website. Includes these 7 items, the first 3 of which pertain to audits, which we'll be discussing today, and the remainder of which detail other issues that are related to the protection of the public in terms of client trust accounts. In addition to these 7 items for the committee's consideration, the committee identified thus far in its discussion an additional set of items. We get to those. The issue of malpractice insurance, attorney conduct issues of failure to communicate and threats to withdraw representation in the face of complaint, the additional training to consider for the Office of Chief Trial Counsel, manager, staff, and outside examiners, the use of data to look for patterns of complaints that would improve the State Bar's oversight, and different ways of enforcing and training on the requirements of the very detailed handbook of client trust accounting for California attorneys, which is available on the State Bar's website as well. So that's the overall charge. And now if we look to our schedule for the next couple of months.
And before you go there, Richard, I just want to say, so we took the original charge as reflected in the board resolution and then augmented it based on discussions with the board and with this committee. So now we've got kind of 14 topics that we're going to address, and you'll see those reflected in this roadmap. But of course, should the committee determine that there are additional areas that you want to explore, we can add them to the list. But this is where we've started for now in terms of scoping out and framing the work for our upcoming meetings. Go ahead, Rich.
Yes, and obviously the topics themselves will evolve, as well as this timeline as the committee focuses its efforts on these various issues. So for now, as a starting point, here we are on September 9th, looking at client trust accounts and the random audit programs of other state bars, as well as key elements of oversight programs. The next meeting, we will look for those, perhaps revisit some of those, as well as discuss the use of data for identifying patterns of misconduct. And what you'll see as we look through this is that these issues cascade from one meeting to the next, because the committee will be discussing each of them, may request additional research and recommendation on different issues. And so they will continually come back as the committee evolves towards its final report. So in the following week, we have those 3 plus consideration of malpractice insurance. And then going forward, from there, we have other attorney conduct issues in October, training of OCTC managers, staff, and outside examiners. So if we can look at the next slide, Louisa, thank you.
Louisa.
And all of this leading up and building up to a report from the committee with recommendations, including any changes needed to statutes or rules for the beginning of November, which needs to go to the Board of Trustees for its mid-November report for its consideration. So that's the general roadmap of the work of the committee, and where today's discussion fits in as the starting point for diving into issues of client trust account management. So now, to set the foundation for this, Steve Moad will talk about the basics of client trust accounts. Steve?
Thank you very much. I'm happy to be here. So we're going to talk about what is a client trust account, some of the key concepts in client trust accounting, and how client trust accounting issues generally come to the attention of the State Bar. Thank you. So first, what is a client trust account? Attorneys often handle other people's money. For example, they may receive clients' money in the form of a settlement check, an advance payment of attorney's fees, court costs, or other expenses. If there is a large sum of money involved, or if the money will be held for a long time, an attorney can hold the client's funds in an individual client trust account. When the money is deposited into an individual client trust account, the interest earned on that money goes to the client. It's deposited into that account, and then when the client is paid out, all of that money goes to the client. In addition to opening an individual client trust account for large sums or when money is going to be held for a long time, lawyers who handle client funds also generally have a client trust account into which they pool smaller amounts of money from multiple clients. Because it would be impossible to determine what percent of the interest to which each client is entitled, these pooled client trust accounts must be what's called IOLTA accounts. And IOLTA stands for Interest on Lawyers Trust Account. In an IOLTA account, instead of depositing into the account any interest or dividends on the money, the bank pays the interest or dividends directly to the state bar. These funds in turn are used to support nearly 100 nonprofit legal service organizations throughout California. And in this way, IOLTA really increases access to justice and improves our justice system. If we can go back. Actually, I think we're still on the first of my slides.
Is this the correct slide?
It's fine. It's fine. We can leave it there. So the other thing to keep in mind is that IOLTA accounts can only be kept at approved financial institutions approved by the state bar. So one purpose of a client trust account is to give notice that the funds are being held for the benefit of others. And this is important because if a lawyer owes money to somebody, for example, the IRS, the Franchise Tax Board, or some other creditor, and that money and the client money is in an account that's in the lawyer's name, that money can be seized or a lien can be put against the account. If it is in a client trust account, it can't be seized because it is clearly marked as not being the property of the lawyer. So with that in mind, it's important to understand what money cannot be placed into a client trust account. And that is any funds that do not belong to a client or in which the client doesn't have an interest cannot be placed into the client trust account. If the lawyer places their own money into the client trust account, that's called commingling and is prohibited. The attorney also can't maintain personal funds in the account as a hedge against mathematical error or to prevent an overdraft. So we can go on to the concepts and rules. First slide, please. Thank you. So a couple of key concepts for client trust accounting. First, even when kept in a pooled IOLTA account, client A's money is completely separate from client B's money and from the money of all of the lawyer's other clients. This means the lawyer is never allowed to use one client's money to pay either the lawyer's own obligations or the obligations of another client. Second, the lawyer can only use the amount of funds held on behalf of each client to cover that client's expenses. So even if the lawyer has funds belonging to other clients in the account, if the lawyer pays the obligations of client A in an amount greater than the funds they're holding for client A, they have spent another client's money to benefit client A. And in essence, lawyers can't write a check on behalf of one client at the expense of their obligations to their other clients. Third, in trust accounting, there are really only two acceptable account balances. Those are a positive balance, meaning that you are holding money for a client, or a zero balance, when all the client's money has been paid out. A third balance is theoretically possible, but if you have a balance of less than zero, or a so-called negative balance, you also have a problem. If a lawyer has a negative balance, it is at best a sign of negligence and at worst a sign of theft. Fourth, as you all know from your own lives, you can't write a check against money until you've received it. Equally important, you can't it can take anywhere from a day to several weeks after you make a deposit before the money becomes available to use, if you will. A client's funds are not available to the lawyer to use on the client's behalf until they have cleared the bank. This is important because insurance settlements in particular can take longer to clear the bank than other types of checks. So lawyers must be particularly vigilant about making sure the money is available before writing a check against those funds. Sometimes lawyers are tempted to write a check to a client even before the insurance settlement for that client or other funds, frankly, clears the bank. They do it knowing that there's enough money belonging to other clients to cover the check. But when they do that, they end up violating concepts 1 and 2 by paying one client using money belonging to another client. The fifth concept is that there are 2 kinds of balances that the lawyer has to be aware of. The first is the running balance of the money a lawyer holds for each client. And the second is the running balance of each client trust account. Because there's no such thing as a negative balance, lawyers have to know how much money is in their client trust account overall before writing a check against it. Similarly, because a lawyer can't use one client's money to benefit another client, lawyers have to track the running balance of the money the lawyer is holding for each individual client before writing a check against that amount of money. Sixth, the goal in client trust accounting is to make sure that every dollar you receive on behalf of a client is ultimately paid out. The money that comes in for each client must be equal to that goes out for each client, no more and no less. And finally, an audit trail is a series of bank created records like canceled checks, bank statements, what have you, that make it possible to trace what happened to the money. The audit trail should start when the lawyer receives funds on behalf of a client and should continue through the final check issued against those funds. And that good audit trail should include the initial deposit slip, bank statement, the checkbook stubs or ledger, the canceled check, the bank, and copies of the front and back of any executed drafts. If you can go on to the next slide, please. The rules of professional conduct are meant to support the concepts that we just discussed. So for example, rule 1.15 is one of the main ones about safekeeping of funds and property of clients and other people. So rule 1.15 paren A requires that all funds, including fees that have not yet been earned, must be deposited into a bank account that is clearly labeled as a client trust account. Rule 1.15 paren C, with limited exceptions, prohibits lawyers from depositing their own money into a client trust account and requires that they withdraw at the earliest possible time any money in which the lawyer has an uncontested interest. So as they earn that fee, they are supposed to withdraw that money from the client trust account. Rule 1.15 paren D paren 1 says that when lawyers receive money or other property on behalf of a client, they must promptly notify that client that they've received those funds. And rule 1.15 paren D paren 7 requires lawyers to distribute promptly any funds owed to the client. Rule 1.15 D3 and E requires lawyers to keep 2 kinds of records. Records created by the bank that show what went into and out of the client trust accounts, and records created by the lawyer that would help explain those transactions. Those could be a ledger that they've kept on their own, accounting for when the money goes in from one client goes in there, notes on the memo line of checks or deposit slips, etc. Rule 1.15 paren D paren 4 requires a lawyer to promptly account in writing to the client or third party for whom the lawyer holds the money. And rule 1.15 paren D paren 6 states that lawyers shall comply with any order for an audit of those records issued pursuant to the rules of procedure of the state bar. So the state bar in certain circumstances does currently have the ability to conduct an audit. Obviously, that's one of the issues that you all are examining. And so some of those rules may need to be updated to comply with the proposals that you come up with. we can go to the next slide, please. So the primary sources of complaints involving allegations of mishandling of a client trust account are clients and banks. Clients sometimes report that a lawyer has failed to pay, failed to account for funds that were held in trust, or even sometimes that the lawyer has misappropriated funds. Those aren't directly implicating client trust account handling or client trust accounting issues, but sometimes that results in discovering that there are client trust accounting issues. And the other way is through what are commonly called bank reportable actions, or bank RAs. And Business and Professions Code section 6091.1 requires banks to report to the State Bar any non-sufficient fund activity on a client trust account. OCTC attorneys review these client complaints and reportable actions in intake to determine if the conduct merits an investigation or an alternative to discipline, and then acts appropriately. They may send it forward for further investigation, including looking at client trust account records and conducting an audit. Unlike complaints from clients, OCTC can and often does contact the respondent attorney at the intake stage in bank reportable action matters to get their explanation of what has happened, and the cause for the non-sufficient funds activity. As you guys will discuss, and as you'll go over with Richard Schaffler, there are lots of changes that we could make to improve the State Bar's ability to audit client trust account records. But as I mentioned earlier, we have to keep in mind that some of the potentially helpful solutions may be precluded under current law. For example, the rules of the State Bar of California require attorneys to report compliance with the State Bar's IOLTA program. This means that if an attorney opens or closes an IOLTA account, those are those pooled accounts, they have to notify the State Bar. As a result, the State Bar is aware, or at least should be aware of, all IOLTA accounts. But the same rules don't apply to individual client trust accounts. And so any audit program may require a rule change to require lawyers to notify the State Bar anytime they open a client trust account, as opposed to just an IOLTA account. Also, under current rules and statutes, the State Bar is limited as to when we can conduct a client trust account audit. And so if we want to implement some of the other strategies, including random or targeted audits, we would need to seek statutory or rule changes. I'll hand it back to you.
Thank you, Steve. And it's worth noting, and we'll see in a minute, the very specific requirements that Steve outlined about the accounting practices are similar to, but not identical to, accepted accounting, just regular financial accounting practices. So part of the tension that states have navigated who've set up these programs has to do with getting accountants and attorneys to understand that practices that may be acceptable in certain kinds of finance for their business or their personal life are not the same as the accepted practices for these accounts. It's a really important point. All right, so let's take a look. First, a brief history of what the bar has done in this regard before, and then we'll look at state programs. And then finally, we'll go over to Australia and Canada. So these four reasons that were originally outlined in the Regulation and Discipline Committee work in 2014, which I'll describe in a minute, are the basic reasons why state bars undertake this proactive management to ensure public protection. One is client protection, obviously. The other is education, educating the attorneys as to what these requirements are, especially solo attorneys who may not have anyone mentoring them. Also educating the public as to what they have the right to expect in this regard. Also the functions of deterrence when you create a climate that includes audit and review and oversight in an active manner. That alone creates a certain deterrent effect. And finally, the issue of, obviously, of detection of the vast number, 98% in most jurisdictions of problems that are discovered are minor errors that require some remedial action, some education. They are not serious misconduct. There are, of course, those cases, and when those happen, they are extremely serious, both from the point of view of harm to the client, but also from the perception of the regulatory entity who's responsible to oversee. So fraud, when it happens, is a low probability but high risk event. The other ones are high probability but lower risk. So we'll talk about more of that in context as well. So in 2014, the Regulation and Discipline Committee initiated an exploration of establishing a more proactive program for managing client trust accounts, and went so far as to hire a consultant who developed a proposal, which is outlined here. And that, as far as the written record goes, is about as far as we could trace this effort. It did not proceed. The reasons for which are not exactly clear, but you can see what they were outlining was a way to try to identify an appropriate set of attorneys to be audited. And that's one of the key design questions when you're designing a compliance program, as we will see how different states undertake it. So we'll look now to some states that have set up these programs. These are presented in alphabetical order. See the state, the year they established their program, and then the different characteristics of the programs. In Connecticut, they engage in a truly random selection. They choose about 2% of their licensed attorneys a year for audit. They initiate that with a pre-site visit mini survey to get a description of how the accounts are managed. And then they issue a random audit report card that has about 50 items in it. They're looking at data for 6 months or more. They have a couple of full-time staff that do this. These audits, the overwhelming number of these result in remedial action, instructional action, and very few of them result in any serious allegations. Delaware, variation on the same theme. There, a firm can engage a certified public accountant to audit their accounts and certify them for compliance, in which case those attorneys, as they say on their website, are not likely to be selected for audit, although the bar retains the right to do that. And every year, attorneys file when they renew their license and the fees, they file a statement indicating they are aware of and complying with the rules pertaining to client trust accounts. This is a feature that many of these programs have. If the attorney or firm does not engage their own CPA, then the state bar retains CPAs to certify compliance with the rule. Iowa, you'll see they audit a lot more, but they audit less. What they're doing there is they are really looking only at, as I understand it, and again, the proviso here is all of this information comes from surveys, from data collected by the American Bar Association and from the state's bar's own websites. Some of those are extensive, some of them are less so. So where there are question marks, it indicates it's not clear, and I have queries pending with those. Iowa, they're typically looking only at that process that Steve described of the what's called three-way reconciliation between the client ledger, the bank statement, and the firm's bank statement. So that's why they're able to do such a larger volume. It's very narrowly ranged, plus they're looking for a shorter time period. Moving on to the next set of states. New Hampshire, a small state that really does because of its size, the volume of this is quite low. New Jersey has one of the oldest programs in the country and published extensively about it. You can see that they look at 2 years worth of data. They have in-house staff doing this. They are auditing about 1%. So the feature, and just to be clear, they've been doing this for almost 40 years, and in that time, about 1.5% of the audits reveal what they call serious ethical violations. About half of those, which are about 234 over the 40 years, result in disbarment. So again, problems are rare, but when they happen, they are serious and they're dealt with seriously. And North Carolina has another variation on this, random selection of the districts. They have 41 judicial districts, and then they randomly select attorneys within those districts. They had an interesting issue there, which is worth noting, which is when they set this up originally, they said, but if you have a CPA certify your client trust account, that's good. We'll take that we'll accept that as certification. The problem was they had not promulgated any standards or done any work with the CPA community as to what their audits were supposed to consist of. So they were narrow financial audits, which did not comply with the rules of North Carolina. So they had a collaboration with the statewide CPA Association. They came up with standards, and now that they correct that program defect. Moving on to the next, just trying to highlight a few things here. Washington has again, similar, but there, if you have been audited, then you become exempt for 7 years. Most states don't have such a provision, but they chose to go that direction. And again, the main purpose, they emphasize that the overwhelming purpose of their thing is to educate, or their program is to educate the bar and to train and support attorneys to do this correctly so that nothing does go wrong when they find minor error, that doesn't turn into major error. So those are some of the flavors of states doing these proactively. There are also another set of states that have a rule on the books that allows them to do random audit, but they do not do it on a systematic basis. Arizona dropped, they never developed the guidelines to permit those random audits to go forward. The other states have it on the books, but do not actively do it as the previously mentioned states. So if we can go on from there. So those are the handful of programs in the US that engage in some form of auditing or have a random audit rule on the books. As you see, it's about 6 states who are actively doing it, and 3 or 4 that are retain the right, but do not do it on an ongoing systematic basis. And now for 2 examples, I'm sorry, if we can back up 1 second. There's 2 examples I want to go over briefly that indicate a very much more thoroughgoing and proactive approach. One is in Australia and one's in Canada. So in Australia, the equivalent of the bar is the Legal Services Board and Commissioner. They do compliance audits. They originally audited every single law firm and attorney, which they switched in 2017, I'll mention in a minute. And you can see they audit a higher percentage, 9% as opposed to 2 for most state programs in the US. And the auditor is the CPA appointed by the law firm, but approved by the board. So again, much tighter control. And if you look at these other features, so their risk-based approach they went to in 2017, if we can go next slide, because as it says there in bold, it was too resource intensive to just keep auditing every single entity. And they wanted to develop a way to focus their resources and efforts to where the greatest risk might lie. They have legal support for that approach. And if we go to the next slide, you can see the outcome of that in the most recent year for which they reported, where they reported, well, so their risk-based approach is defined here. You know, basically they're looking at the probability of something happening and the harm of something, the degree of harm of it is the result of it happening at all. So they're trying to balance those 2 things. So if you go to the next slide, you'll see that in the last year for which they have reported data, they did about 2,200 audits. They got identified 465 what they call breaches. Of those, if you look at the bottom up, you'll see the rows with the numbers 1, 5, and 3, those are the 9 serious cases out of the 313 that they ended up investigating. The overwhelming numbers at the top are ones, as they say, light touch, compliance, education, remedial work. Again, important to correct so that things are done correctly and that the profession holds to the standards that they should be held to. We can now go to Canada. Here is universal audit. Every single law firm attorney is audited. They must use an accountant approved by their law society, which is their board. So this is the province of Alberta. They also then dig deeper into this, as you see in the next slide, the system by which these accounts are set up. Steve mentioned earlier the policy question of whether client trust accounts should also be registered with the bar, like IOLTA accounts are. Well, you'll see here what happens in Alberta is a firm has to appoint a responsible lawyer who is the person in their firm responsible for these accounts. They then have to, and that person has to be approved by the board, by the bar, and they then set up accounts. The accounts have to be registered. They have to engage an accountant to file what's called a startup report so that there's an independent verification that this account has been set up properly. And then annually, the firm and the accountant submit reports, or the board has approved 8 software programs that are designed to perform the accounting required on these accounts and to report that electronically through their portal to the Law Society of Alberta. So that's a lot of data on a lot of accounts, and they use Pricewaterhouse. They outsourced that in 2017 and use PricewaterhouseCoopers as their current vendor to do the analytics and look for anomalies. When they find anomalies, when they find outliers, when they find things that don't look right, they then go in with and examine those accounts in more detail. So the purpose of gathering all this data is to actually analyze and develop profiles and develop norms and normal ranges, expectations for certain kinds of expenses and levels of activity that they can then use as a baseline to compare these accounts to each other. So lastly, a state and local example, one that might appear odd at first glance, but if you think about it a bit, cemeteries and funeral homes take deposits from people who are looking toward their ultimate demise, and they're either looking to control costs or just to know that it's already been taken care of. So they deposit those funds with those businesses. It's the job of this California Cemetery and Funeral Bureau to make sure those accounts are managed correctly, that the money is still there when it's supposed to be there, and as, again, some of the same kinds of rules that Steve outlined earlier for client trust accounts to make sure that, you know, it doesn't just become a big slush fund that's used for purposes other than those for which it was intended. So they do desk reviews, compliance reviews annually, and on-site desk audits every 5 years as they rotate through this. And lastly, had a very productive discussion with the management team of tax and audit, parts of the treasurer's office in city and county of San Francisco that was facilitated by Jose Sinceros. And through that, we learned that how they created a sense of regulatory culture, a way of looking at data, a way of being able to identify these norms, to look at specific types of businesses in the case of taxes, and also to develop a series of touches, if you will, a range of communications that could be a letter of inquiry, a query, a questionnaire, rather than just have either nothing or a full-blown 6-month deep dive financial audit. There's a way in which that office maintains contact with the communities that it is charged with regulating, and thus creates a sort of presence, which has both a positive effect and a deterrent effect, I'm sure. And knowing that they're paying attention. They're able to do that because of the data that they've gathered and the experience and sophistication of the analysts that look at it. And the same is true on the audit side for the departments, 50+ departments of the city and county. And there again, looking on risk assessment, looking at a variable such as cash handling. You know, how many places is cash collected? How is it collected? Is it cash? Is it credit cards? Is it checks? How many people are involved in that? And developing a sense of how these different departments run and where they need to focus their efforts. And now, finally, the key point was made was that if one sets out to do auditing, one really needs to be sure the rules are clear and transparent to all so that there's no appearance, much less practice of bias in the selection of who is being audited or how they're being audited, and that one can point to best practices in audit to show that what is being done adheres to those professional standards. That's obviously important for the legitimacy of the effort. So, having reviewed this high-level overview of the different programs, here are some of the key elements that the committee might wish to consider going forward. And these appear more or less in sort of sequential order they might occur. One is a question: should client trust accounts be registered with the state bar? A lot of the programs I just saw do that, and also require annual recertification as to the status of those accounts. Should there be some form of annual certification of compliance by the attorney or the firm with the rules and statutes and the handbook that the bar publishes based on those for client trust account management? There are various forms which that is done, but many states do that at the same time that attorneys are renewing their license and paying their fees and certifying this, so that there's a name on a form that someone is attesting that they're in compliance. And then there may be a range of kind of communication strategy, if you will, that goes with such a program, how to look at the data and query the people submitting it, how to perhaps use kind of a slightly more in-depth questionnaire to ask about how these accounts are managed in a certain firm, all the way up to then getting into audits, of which there's really two types: compliance audits, which are really a way of looking at how are these accounts being handled. So it's not a financial audit per se, it's really looking at where are the records, who manages them, where are they kept, do you do the monthly reconciliations? In Australia, when they do those examinations in that program, there are 600 items they're checking off to ascertain compliance that are then reported to their equivalent of the bar. So in addition to what type of audit, there's what method should be used for selecting people to be audited. Should it be universal? Should it be random? Should it be targeted based on some risk profile? And then by whom should it be done? Should it be done by staff of the state bar in conjunction with outside examiners, whether those be certified public accountants or some other form of auditor? And then we get to financial audits where the same questions. Typically, those are based on some either complaint or findings in the compliance audit, which suggests there's a need to look deeper. And the same questions arise. If those done by the bar, by CPAs approved by the bar, by other outside examiners of some sort to be determined. So those are related policy questions that go with that. In addition, there's, again, all of these programs emphasize the level of training that they provide and support. So it's not so much a gotcha game as a help ya game that they're trying to do, recognizing that these rules are specific, they're important, and they are more complex than perhaps some attorneys realize. Some programs also assign mentors where they found compliance problems so that somebody has a chance to learn from another practicing attorney how these things should be done. And then finally, the discipline that's associated with them. Many of these programs do not impose any discipline or sanction. It's remedial and educational outcome in all but the handful, 1.5%, 2% of the cases where they find serious, and then they deal with the discipline related to that in proportion to the conduct. So those are the elements that some of the elements, the key elements that the committee may wish to consider going forward. And I'll end there.
All right, so that was a lot.
Yes.
Thank you, Richard. Thank you, Leah. Do you think we should open it up to the committee members for questions and discussion? There's a lot there. I think people might have some questions they'd like to explore further.
Sounds good.
Does anybody have any comments or questions at this time? Melanie Shelby, I see your hand raised. Please go ahead.
Thank you. First and foremost, thank you for that. As a non-attorney, that was a very helpful background and foundation. So I really appreciate that. And I'm going to ask a couple of questions that might seem elementary, just to kind of put some things into context, because this is also very new for me. As it relates, and this first question is probably directed more so to State Bar staff, so to our executive director. As it relates to benchmarking, I thought that was really helpful and useful in terms of the benchmark, but who do we tend to benchmark ourselves against? Because I know that our population far exceeds many of the states that were benchmarked. So when we benchmark as it relates to the State Bar, who do we compare ourselves to typically as it relates to other state bars?
Yeah, that's a great question. I mean, in terms of size, we're typically talking about New York, Florida, Texas. And even that isn't a perfectly fair comparison, because the New York bar, for example, is a bit disaggregated as compared to us. So it makes it really challenging. And you see that both Alberta and Ontario are much smaller jurisdictions as well. So we are the behemoth in the bar game. And there really aren't sort of fair comparators with our attorney discipline system. So it's something that we have to take into account, certainly scalability.
Okay, and I appreciate that, because as it relates to context, right? I was really curious in terms of New York, Florida, and Texas, if there's any, what their programs look like in this area, if they exist. I guess that's one question. And because they weren't in the presentation, I imagine that we didn't look at that, but it'd be great to look at that as we move forward in terms of this work. And then as it relates to just roughly the number of CTAs that exist, what does that universe look like? Because I again, as a non-attorney, I have no idea kind of how to put that into context.
We have no idea. And I think that is a huge light bulb for me has gone off during this recent process. We have information on the number of IOLTA accounts, and Richard, we just had a meeting about it. I really can't remember that number, but maybe we can figure that out. It's in the many thousands, but presumably there are even more CTAs out there, because this is for every individual client, many clients. So we don't have any visibility into that, Melanie, at all.
Okay, that's a red flag. And then my last piece is, as it relates to some of these other states that have large licensees, what would be really interesting is A, if they have any sort of what programs they have around client trust accounts, and B, what the staffing looks like, because I appreciate the information on the other states. And it was very helpful. As a new member to the audit committee, it was very helpful to understand the compliance and the random audits piece, but I'm curious about staffing in terms of how that is carried out. That would be really helpful for me in terms of being able to understand things a little more clearly. So thank you for that, Mr. Chair.
And I know, Richard, you did have the staffing in the slides. We'll send the PowerPoint out to the committee so that you can see that information. Obviously it was moving fast. With respect to New York, Texas and Florida, Richard, I presumably you looked at all 50 states information that is available, and they didn't come up because they don't have a program.
That's essentially correct. Yes. Yeah. And so if you look at New Jersey, which has 40,000 bar licensees compared to California, I believe it's approximately 170,000. Is that?
No,
right?
It's about 200, maybe 205 active licensees.
Ah, okay. So New Jersey at 40 when at the time these data were, they have 11 staff doing this. 11 full-time staff. That's what I'm told. So I'm still working on trying to get good staffing data because I have the same question you do. And that usually requires someone to answer my inquiry about that because that's not the typical stuff they're publishing. So yes, that's a key question.
But that's helpful, Richard, in terms of just kind of context. So thank you for that.
Yeah, Melanie, just following up on some of your questions, I do think that you're hitting on a lot of the points that struck me, which are that this is very much seemingly uncharted territory as far as the State Bar having any kind of information on how many attorneys are engaged with client trust accounts. And so that would be kind of the universe of potential audit targets. And then, what kind of range I think would be interesting to know as well. Maybe so I can see that whatever journey we decide to take on this area would likely be best supported by starting out with a lot of information gathering. It might be some of these questionnaires that we've seen be implemented in other areas, where we ask every licensed attorney if they or any of their clients are using client trust accounts, maybe getting a little information about the range of the size of the balances in that trust account. Give us your highest balance in the last year, give us your lowest balance, and things like that. So we just have an idea of sizing the universe, and so on, or by firm or whatever makes sense for the industry.
Just to add, I emailed staff about the number of IOLTA accounts. It's 48,000, almost 49,000 just of the IOLTA accounts. And the only other thing I wanted to say in terms of resources, these, I think we have to operate under the assumption that any program we implement would be funded by licensees and law firms, not absorbed by the existing State Bar budget. So just want to put that forward.
Thank you. Okay, any other committee members with comments or questions? I'm looking for other raised hands or.
Well, Mark, maybe I'll ping you and ask you a question because I know you have a lot of thoughts about this topic. I was interested to see that in 2014, 2015, this had been a program that was included in RAD's work plan, the development of a fully articulated client trust account auditing effort. Then it died. I did try to attempt to find out why. I know in the conversations I've had with you, I've asked, what is the opposition to this? If the State Bar is going to embark on anything like what we see in some of these other states or other jurisdictions, what are we going to hear back from licensees and law firms? Just so we're fully cognizant of that. And I believe you talked to some attorneys, and I would just love to hear your thoughts.
You're talking to me?
Yeah.
Talking to me. When I hear costs, that rang with me because I was talking with a number of the partners to some of the firms. I might say, of the 200,000 attorneys, I was interested to hear you say that there's only 48,000 IOLTA accounts. And that kind of goes in with what Steve was talking about, is that you have IOLTA accounts, which is sort of the pooling of client account money. And then you have the individual client accounts that's not IOLTA because the interest goes to the clients. I don't know that too many attorneys know about that, to be honest with you. That would be something to look into. But when I talk to the various people
about— they know about what? I don't quite understand. You don't think they know what?
That there are two different kinds of trust accounts. One that's an IOLTA account and one that's a non-IOLTA account, which is still a client trust account. So the IOLTA accounts, the interest money is going to the State Bar, but the non-IOLTA client trust accounts, the money, any interest, if you will, is going to the client's client money. So that raises something with me that you'd have to, if you're going to ask firms or individuals about their client trust accounts, you have to ask for both of those different types of accounts. I know I've got several different kinds of, trust accounts, but when you talk about cost, I got a lot of pushback on that. I was just asking for ideas because the firms were saying that any of those costs would have to be passed on to the client. So for example, we were talking about, I asked them about bonding requirements, the cost of bonds. We came up and we were talking about malpractice. I'm not sure how malpractice would fit into this, but they're assuming you could do it, even there would be a cost. And the firms were saying any of these types of costs would have to be passed on to the clients, and that essentially would eat their profit up, and they would have to raise the rates that they charge the clients. Now, these were mostly PI firms that are taking in a lot of settlement money for clients and things. So they would have these settlement monies for some period of time, up to 6 months, I guess is what I was hearing, because they have to settle these liens and things before they can disperse all the money and come up with zero. And they were very concerned that any of these costs would have to be passed on to the clients, and of course it would go into their pockets. So, and I mentioned to them, we as attorneys right now pay into the client security fund. We pay a certain amount of money in there to cover the cost of the bad lawyers. So I don't know where it is, or if you have any specific questions. One of the things that came across to me was that at the end of a client's case, when you have, you've taken in client money, you've settled the case, whatever it is, that there's a 6-month period of time that settlement has to take place. And that at the end of the 6 month, there would be a report to the state bar, essentially an accounting of what happened during that, that time. So I'm thinking, that we would have to register all client trust accounts, IOLTA and otherwise, when they're opened. And at the end, you would have to, I guess, self-report. But those are some of the ideas I got from some of the firms.
Thanks, Mark. And just to follow up for a minute, the 6-month period to settle and make all necessary disbursements. And just to clarify, right now, there is no time limitation on disbursement of funds from the client trust account, right?
That's my understanding.
Yeah.
And looking back on the report that we've been looking at, that was one of the issues, that there really was no reporting of any of these settlement funds from clients. And the only time the bar ever got wind of anything was when a client complained. It's been a long time. He hasn't, sent my money. And from what I'm hearing from Melly and others, that's kind of how the bar would get notice of it. And the reason they said 6 months, I personally, although I don't handle big, settlement funds or anything like that, it's usually just cost per cases and things. Or if it's court money or something, there's usually, I have a rule of thumb like 30 days. And the courts generally will require 30 days. But again, I'm not dealing with, and the one that came up quite frequently was Medi-Cal liens. They're very hard to deal with. That's why they came across with this. It takes 6 months to sort of negotiate those types of settlements after the settlement's completed. That's why they came up with the 6-month type of thing. And then if it takes longer, you would petition the state bar or something to say, I need a little bit more time. I expect it to be resolved within a certain period of time and so forth. So at least the bar knows what's going on. And then there is a specific requirement to report at the end of a case.
Thank you, Mark. I saw Steve, who had a hand up, followed by Sean Seleg.
Thank you. I would just add to what Mark just said about some of the feedback that the bar heard from attorneys in general and from Discipline and Defense Counsel when this was brought up in 2014. And I want to reiterate what Mr. Schaffler said, which was that we don't know why the that process was abandoned back in 2014. I don't know that it was a result of these criticisms, but in the interests of this committee's charge, I thought it would be appropriate to bring them up. One of the criticisms that was recited at the time was that it would make it difficult, or at least complicate, maintaining attorney-client privilege, that by giving the state bar the ability to go in and audit accounts and see who clients were, et cetera, that in some circumstances, the mere fact that that an attorney had been retained may violate the attorney-client privilege. I don't know how widespread that particular complaint would be, but I do know that there are some cases that support the proposition that just a list of the attorney's clients in certain circumstances is attorney-client privileged, but those are relatively finite. Another concern that we heard was that simple technical errors may result in discipline. I don't know that that's really the case. The State Bar has never prosecuted for mere negligence. It's really something above that. And as Mr. Schaffler mentioned, the other states all have varying degrees of discipline that could be imposed as a result of some sort of misfeasance or malfeasance. And so that could certainly be dealt with, but it was a concern stated. And finally, that an attorney's statutory duty to cooperate with a state bar investigation, and in this case, a state bar audit, may be in conflict with the attorney's Fifth Amendment privilege against self-incrimination. So those were the three, at least that I could readily find when this came up in 2014.
Thank you. Sean?
Thanks, Jose. I'm just going to bite my tongue about the Fifth Amendment issue. So on these the various flavors of potential auditing requirements that have been set out, Mark raised the issue of cost. It seems to me that it would be good to do a couple of things if it's the will of the committee, and that is to look into these auditing proposals, and that is to find out how much they would cost. So I think it seems to me the most practical way to do it is to have a list of approved CPAs, and that I think for attorneys with a really simple trust account, it's not going to be very expensive. I think for those who have big, complicated accounts with thousands of transactions, those are high. We've learned that those are high risk matters, and that's going to cost more money, but it may be necessary to protect the public. And in terms of the costs, I would say that one thing we haven't expressed outright before is that someone mentioned that attorneys have to contribute to the client security fund, which reimburses clients who have dishonest lawyers who steal their money. And presumably the payouts from that fund would go down if this auditing procedure was effective. So that could be a cost savings for lawyers. Although in fairness, I think the annual audit, for example, is going to cost well more than the current CSF fee. So I think we ought to start costing this out, how much it would cost, what the factors are for the cost. And if we're going to consider, I guess the final thing I'll say is if the options on the table are not mutually exclusive necessarily. So for example, we could have a random audit program and a high risk program that based on certain factors, the high risk accounts are audited more frequently. But I think we ought to start getting real numbers on the cost and start figuring out what our criteria would be for high risk accounts if we go down that road. So just a few thoughts.
Thanks, Sean. Anybody else, comments or questions on the presentation?
Just wondering how we know there's 48,000 IOLTA accounts. When they're open, does the bank have an obligation to report an IOLTA account to the bar, or does the attorney, or how do we know that?
There's two ways. One, the attorneys are required to inform the bar each time they open an IOLTA account. So it's a requirement specific to IOLTA accounts. And then we also receive directly from banks statements on their IOLTA accounts. So we have two sources of information, and a whole separate issue that Richard and I have been exploring is what is the bar doing with respect to these two different data sets, just even matching what the attorneys are reporting and what the banks are reporting. But we do have the 48,700 number comes from what we've gotten from the banks.
Thank you, Leah. I would just add that, that type of information that we have on the universe of IOLTA accounts, and particularly to Leah, to your point, where we get the theoretically, or in reality, the reporting from two different sources, namely the attorneys or the law firm and the bank itself, is a very, very beneficial landscape to be working on when we're trying to figure out what things look like. And I think it kind of begs the question of if we can have that kind of rigor and information about, one universe of client trust accounts, why we wouldn't be able to create it for the entire universe of client trust accounts, whether they fall into the IOLTA category or not. And we clearly have an example right here in California where we have a lot of information, and the attorneys have managed to comply with all the requirements and hopefully are doing things the right way, and also at the same time giving a lot of information and transparency to the regulator, namely the state bar. Ruben, I see you have your hand up. Please go ahead.
Thank you, Jose. Similar to what Sean mentioned at the very last portion of his comments, I was wondering during Richard's presentation what would constitute a high risk type of account or law practice among the or other jurisdictions he surveyed. Was there any information about that?
The short answer is no. I think one of the things that the jurisdictions that I was able to contact did emphasize was that it's really sort of it's like a camel, the distribution. So you have a big hump here of small firms and solo attorneys, and there are many, many issues there, but they're small issues. The account is $500. They're off by $10. It's not right, but it's not egregious bad actors. It's just somebody losing track. And then at the other end, you have huge international law firms that are getting hundreds of millions of dollars in these trust accounts. And so the potential, one would like to imagine that they're also staffed in a highly professional way, but it also means that that's where if something goes wrong, it's a big deal. There was a 2016 federal case in which there were two very prominent US law firms that were said to have allowed hundreds of millions of dollars offshore money to pass through them where they should have taken note. I'm trying to be very careful about how to describe this, but they were not being charged with this, but it was pretty clear that when hundreds of millions of dollars are being deposited and then spent for artwork and ironically an investment in the Wolf of Wall Street film, then something is amiss. So I think there's a wide range of the size of these accounts, the big volume, small dollar amount, and then the smaller volume, but big dollar amount, and then some stuff in the middle. But we don't, as Leah said earlier, we do not know the exact profile in California. And so the risk profile, the exact algorithms that are being used in Canada and Australia, do not know. Can certainly seek to ask.
Okay, thanks. Jose, I don't know how to lower my hand, so you can ignore it if it's still up.
Okay, thanks. Anybody else with questions or comments at this time? Yes, Mark.
I just had a thought. This hit me ever since last time we talked about this. Is an attorney, or should an attorney who has 15 plus complaints against them, should they have unfettered ability to manage client money without some form of oversight or something else? That's really bothered me since. I don't know what that number is, whether it's 5 or whether it's 15. But I think we should look at that. You know, if an attorney has had so many complaints, even though it's unnecessarily for mismanaging accounts, should that attorney be allowed to handle client money without some sort of oversight?
Great question.
And the oversight, Mark, would be like an escrow. It would be like an escrow account.
Escrow, bond, something, you know, something we come up with.
Okay, great. Helen, you're nodding a lot. We haven't heard from you. Anything you would like to add to this conversation, this rich conversation?
No, I mean, I agree with all the points that have been made. I do think, I mean, I'm intrigued by the proactive, you know, regulation and oversight that Richard described. I think we really need to consider it. And as Sean said, figure out how much it costs. I mean, I guess we'll have to figure out what percentage of accounts we'll look into and kind of, you know, because that will drive staffing and budgeting.
Right. Yeah, let me add on to your comment, Helen, and thank Richard specifically and everybody who, Steve, Lee, and everybody that worked on this, preparing this information. I think it's been very rich and very helpful. I'm particularly encouraged by the reality of the regulation and transparency in place for the funeral and cemetery industry. You know, it's examples like that. It's existing practices like that I think can really steer us towards a clear path that will allow us to do something similar, adapt their model, whatever it might be, of course, with clear insights into the differences between our industries that we're regulating. But the fact that, you know, the entire industry for the state of California that handles clients' monies is so clearly and so closely regulated, I think makes it's clear evidence that this task is possible. And we just need to figure out how we can learn from those already doing it and adapt models from other places to figure out what makes most sense for California. So thank you to all your information for the information we've gathered, and I know we'll be coming back to this. Leah, what were we going to move on to next?
This is our agenda item for today, so you guys are getting through it pretty quickly. I don't know if you intend to still have your hand up, Richard, but I thought maybe we could recap what we've heard. I'm unfortunately having some technical difficulties over here.
Right. While you're solving those, let me just be responsive to the question you raised earlier about what might be objections. I would say that looking at these programs and looking at their histories and looking at the ABA's model rule, the ABA's model rule encompasses random selection, and they have very specific language about the fact that you have been notified that you are going to be audited may not be interpreted as an allegation of any wrongdoing, guilt, et cetera, et cetera. So, and states understandably go to some pains to demonstrate how exactly they do random selection, because having worked in the courts many years, when you use the word random, some people think, oh, every other one. It's like, no, that's not random. I mean, there's kind of folkloric ideas of what that means. And in a state that's large like California, one of the things, there's also different flavors of randomness. You can have stratified random sampling. In other words, you could say, we're going to take this many from large, you could stratify the firms by size, you could stratify geographically, you could stratify by practice type, as long as there's a reasonable justification, substantive reason why you're choosing to divide the universe that way, and then sample within that. Because the danger if you don't do that is that you may not get a representative sample, especially in a state as big and diverse as California. So that is one question of, And then I think there's a question, Steve Moyer and I were talking before the meeting about risk-based or targeted auditing, and whether, that's another issue which needs to be, where objection can be raised about, well, do you have cause or do you not? Because if you do, then you should investigate me. And if you don't, then you shouldn't. I shouldn't be audited. So, but that's true of a lot of the risk assessment tools being used in the justice system today, whether it's in pretrial release or post-adjudication sentencing by judges, where data is being used to try to help these institutions make the best use of the resources they have in a way that will actually achieve the purpose of public safety, or whether it's sanctioning or public safety or both. So those are, can be complex discussions, but they're worth having as you explore this, I think, as part of the policies design that you come up with.
Your comments, Richard, reminded me of something that struck me in your presentation, which is that, and maybe I can't remember if you made this comment in connection with the Canadian jurisdictions, but this idea that when you're conducting an audit, it is not so much this like, oh my God, I gotcha and I caught you doing something wrong, but there is a culture of, this stuff is complicated. The rules are technical and hard to understand. And part of this is we're here to help you. This is part of helping you identify issues so that we can help you. It's a learning process for some people because these rules are so hard to understand. And perhaps it's a way, I think we need to think hard about how we can frame it as such, so that it's not just a like, oh, let's just be always afraid of an IRS audit, but it is really part of a sort of proactive, education in the way that we've talked about before, right? When Steve, you brought that woman in to talk about, doing self-assessments and checklists, and perhaps there are sort of educational type best practices and information we could be more proactively providing to people when they open IOLTA accounts, or checking in with not so much like a heavy-handed, we're going to come in and audit you, which sounds really scary, but sort of proactively, here are some checklists of best practices, go through it and, certify that you're doing those. And just sort of a self-assessment tool that can also help people just practice good hygiene. Because especially, and this makes me think about the Farkas report, right? The extent to which Black attorneys, solo attorneys, people get subject to more discipline. We have to be aware of that when we're talking about imposing this audit process. Are we doing it in a fair way? And can we do it in a way that also just recognizes that for many people, more education and prevention is what's needed?
That's a great point. And it made me think that right now, the handbook on client trust accounting that's on the State Bar website, it's available for download only right now, right? So we could actually look at some download data and see, is anyone downloading this thing? That handbook is extensive, and it's really well crafted. It has not just the rules and regs, but it shows you visually, this is what a ledger should look like. This is how you handle this kind of transaction. It's a real how-to as to doing this. So it's a great tool, whether or not there's awareness, as was brought up earlier, and use. That's a great question. And I think you're right. Everybody that I have managed to connect to in these programs, it's a huge emphasis that they make about what they do and why they do it. Is exactly what you're talking about.
Yeah, and just one more point, and I know Steve has his hand up, but it can seem daunting to go through like a whole gigantic downloaded handbook. But what if the State Bar were to push out sort of like 60-second, 90-second, like here's a bite-sized information piece just to keep people up to speed and up to date and always learning. So like our law firm is a member of ALAS, the Attorney Liability Assurance Society, and we are always getting pushed out these sort of like 90-second bite-sized, like remember the importance of client engagement letters, or remember certain things to keep your firm safe from a cybersecurity attack or whatever. And it's just a little bite-sized reminder. And we always push them out to our attorneys because it's just a good chance to be like, oh yeah, I should make sure I'm doing that.
Great point. Okay, Steve, followed by Mark.
I would just say that at least one person has downloaded the handbook, because I've downloaded it. So that's a tick mark in the right direction. I will say that as we have talked about self-assessments, the first piece of the self-assessment that the Office of Professional Competence is working on is on client trust accounting. And it certainly could be that the board requires, for example, somebody who opens a trust account for the first time, or even opens one anytime, that they have to go through that self-assessment. And I am hoping that that really will drive home the points about best practices and get people in the habit of using those best practices in managing their trust account. But I hadn't really thought about the sort of smaller bites that you just mentioned, Hyland, and I love that idea. I think that's fantastic. Whether that goes out to in the all licensee emails or social media, or is more targeted when people open accounts and we have a list of people who have those accounts and it goes out there. I think that's a great idea.
Yeah, and I would just add to what Steve, you and both you, Hyland, are saying is, I think those helpful tools can come in a lot of different forms. I mean, what we've seen in a lot of industries are the idea of checklists, right? So maybe a 1-2 minute checklist that you could run through and say, every time you open a client trust account, complete this checklist. Did I do it this way? Did I set it up? Did I inform? Did I account for it? Did I handle it? Did I tell the client the right things? All those things. Just do a simple check, 10-point checklist every time you do one, or at the end of every year for one, or something like that. Simple tools can be both helpful and educational at the same time. Mark, please go ahead. Mark, you're muted.
Here's my client trust account book, which is always in my little thing back here. I like the self-assessment idea that Helen is talking about. I mean, God, I hate to say this, but perhaps you could add it to every 3 years we have to, do our MCLEs. You can add on there that they have to take so many units of client trust account law, so to speak. I'm going to throw this out. I may be an old guy, the oldest one here who remembers any of this, of the attorneys, but we used to get the California Lawyer magazine every month. We don't get the California Lawyer magazine anymore. We get something online, whatever it is. But in the California Lawyer magazine, in addition to little op-ed pieces and things about law, there was always this section on discipline. And they would have everybody in there for the last month who got disciplined and what it was for. Right? So sometimes it would just be reproval, other times it would be disbarment. Of course, you wanted to look in there and make sure your name was not in it, but you'd look also to see who else that you knew in your general area was on the list, what they got disciplined for, and you could always see what it was that they were being disciplined for. I found that to be very helpful and of course very interesting. We don't have that anymore, but I miss that. The other thing is, maybe Richard, I wanted to ask you, did you look into, or does anybody know how escrow companies, escrow industry is regulated?
I did not, and I do not know that, but certainly can take a look.
And that's maybe a good segue, Jose. I was wanting to kind of go over what I've heard today and kind of talk about next steps for information that we're going to gather. So first, on sort of questions of scalability, we want to make sure we're focusing, I think, on the largest jurisdictions and understanding what they're doing and how they're paying for it. I think that will be important for us to understand. And then I've heard from several of you this idea of moving towards requiring registration of all client trust accounts. I'm calling it registration, but notifying the state bar about all client trust accounts, not just IOLTA accounts. I heard, I think from Sean, about requiring trust accounts to be independently audited. So not the idea that the state bar is going to be the entity per se doing all the auditing, but that there would be potentially an audit requirement by an approved CPAs from an approved list. That's a concept that we might want to explore further. But then in addition to that, there could be some auditing done by the state bar, either auditing on a random basis of those independent audits, or using data and analytics to determine a risk profile the state bar doing some additional auditing of high risk respondents or law firms. So kind of keeping all of those issues at play. And then on the some other issues I think you raised, Mark, should there be a point at which an attorney loses the ability to independently manage a client trust account? I want to ask Richard to look back at some of these other jurisdictions and see if anyone's doing something like that, because that's an interesting idea. And then on the preventative education, we did, I think, recently came to the board an update on the module that Steve was referencing. And certainly we could look at that a little bit more carefully. I know I need to see what it comprises right now. Is there in fact a short checklist element now? I love the idea of integrating video. So it sounds like we will have an educational piece to our recommendations as well. So
Can I add one thing to that, Leah, that I forgot to mention? I don't know, and maybe Steve or Richard or Melanie can answer this, is when an attorney opens a client trust account or an IOLTA account, is that attorney required to give the client any information about sort of know your rights, or here are your remedies, or here is what you should expect, here are the things that should be, here's the way it should be done? I think there's a lot of focus by regulators. I mean, I represent a lot of schools and colleges and universities. They're getting investigated all the time by the Department of Education or by the Office of Civil Rights of Health and Human Services. And a huge part of their regulation is, are you giving students proper information about what their rights are so that they know that they have the right to report their sexual assault to law enforcement, or their right to report it directly to the Department of Education. And here's the resources and here's the information that you have to provide to them. And when they get investigated, these schools and universities have to hand over evidence that they are distributing this in various ways on their website, in person, they're doing trainings, and they're having to confirm, yes, we are providing all of this information.
That's great. It's a lot of good examples out there of how other industries have tackled, you know, informing everyone involved in the transaction and things like that. There's certainly a lot of, you know, you've been informed of this in medical transactions or real estate transactions and all that type of thing. So
Right.
getting that kind of sign off by between an attorney and a client would just be a very simple thing to add perhaps to the picture. Mark, please go ahead.
Yeah, I don't think there is, except at the end. I mean, Steve can probably correct me if I'm wrong. And nowadays, you know, you have to let the client know if you're going to be putting fees and perhaps unearned fees, flat fees, that kind of thing into a trust account versus a general operating account. But I don't think so, but it might be a good idea. The other thing that I was going to mention, we talked about patterns before and things like that. I have had the occasion over my practice to, I guess for lack of a better word, sponsor 4 or 5 attorneys who had gotten in trouble for various activities, usually addictive issues, whether it be alcohol, drugs, gambling, sex, that type of thing, and would have to sort of help them through their issues. And I do know that there's quite a bit of financial problems that sort of cross over with attorneys who have those kind of issues. You see it all the time, you know, you get into a little trouble, and so you dip into the trust account and you'll say, oh, I'll make it up next month, or I'll cover it when I get this settlement check, or whatever it is. And the next thing you know, it snowballs and snowballs, and you've got a huge problem. So it may be that in addition to looking at just 15 overall complaints or things like that, that you also want to look at the types of issues that they're involved in. And if they're involved in this type of activity, that may be something that would require additional oversight by the bar.
Thank you. Leah, thank you for that summary about going forward. I do think there's a lot of stuff to look at out there. I think I very much like the tenor of the conversation we're having, where I think it includes not only some strict forms of discipline and oversight, but also a lot of partnering and educational communication, hopefully non-threatening, if not even helpful communication between the state bar and the attorneys, particularly on this topic. And I really do think that getting attorneys to, I mean, we're all busy. I'm sure all attorneys are busy, and they don't always think about things as they're doing them, and don't have the time. And this is just, you know, asking simple questions or having simple requirements to report various things, gets someone to just pause for a moment, think about what they did with regards to this topic, client trust accounts. And by simply answering a question, that will jog their mind to check and make sure they did it all the right way and that they covered all the bases. I will say that the other thing I would hope we would also be sure to keep in mind is that whatever we put in place, we can, as I think you've mentioned numerous times, Richard, is we can right size things. You know, more reporting is obviously perhaps appropriate for larger firms, larger trust accounts, larger volumes of dollars, that type of thing. Audits certainly might be something that would not be required of absolutely every client trust account utilizing attorney, but certainly above a certain threshold, things like that. And I think that it's a very viable option to use the accounting industry as our partner in this, so that they could be on board to at least have a first pass or the universal pass at all of these transactions. And then that by reviewing their findings, we can quickly see if there's any anomalies or anything that deserves further attention. And I'll just say that, you know, the concept of random audits is a time-tested and very valuable method that's used in a lot of industries. It can be very modest, as you saw, Richard. You know, the number of audits that many of these jurisdictions performed were in the 1%, 2%, very, very small number. But just the idea that they happen do encourage, you know, people to stay vigilant, stay on top of their matters, just in case, you know, their name should come up and they should be the subject of a random audit. So I think I like a lot of these ideas, and I'm glad we're talking about them.
Great. I think we have our marching orders for the next meeting. Sounds like there's a lot that we're going to need to research and bring back. Maybe we'll start to map it out in a way that begins to look like potential program design elements.
That'd be great.
Okay, and Louisa should have emailed you all the PowerPoint as well from today.
Oh, great.
Okay.
All right.
Thanks,
Unless
everybody.
anybody else has anything else, I think we're ready to adjourn the meeting. One last call for any comments. Seeing none, with that, we'll adjourn the Committee on Special Discipline Case Audit meeting for today, and thank everybody for coming. Thanks, everyone. See you
Thank
later.
you.